Well, this is the roster we have now. These are the people who will decide our laws for the foreseeable future. It's been a year since Justice Brett Kavanaugh was elevated to the Supreme Court in a valiant journey of shedding white crocodile tears to deflect accusations of sexual assault. God forbid this young man's future be tainted. Take that, liberals! You just got owned! While we had some important cases during the last year, I get the impression that the court wanted to lay low, since rocking the boat too much after the whole Kavanaugh thing would have led too many folks to question the integrity of the institution. A year later, Kavanaugh is just there. He's a Supreme Court justice, just like the others. We done goofed when we let that happen with Clarence Thomas 2 decades ago, and we done goofed again now, and we're about to pay dearly for it. See, while last year we didn't have much to cover in matters of social justice, this coming year is loaded with very far-reaching cases, and we gotta be prepared to face them as they come. That's what I want to talk about today, so we'll have a brief overview of the cases scheduled by the Supreme Court for this new term. I will go into more detail in future videos, as each case gets ruled on, but for now, let's just dive in and see what to expect in the coming months. By the time this video is up, a few of these will already have crossed the court, so let's start with those. If you've paid any attention to the news, I'm sure you've heard of the 2 LGBTQ+ cases the court heard on October 8th. The first one, Bostock v. Clayton County, is on whether people can be fired from their jobs on the basis of their sexual orientation. Then there's RG and GR Harris Funeral Homes v. Equal Employment Opportunity Commission, concerning whether people can be fired on the basis of their gender identity. Bostock revolves around a gay individual who used to work as a child welfare services coordinator for Clayton County, Georgia. During his entire time in this position, Bostock received outstanding performance evaluations and he was, by all accounts, an exemplary worker. Then he committed a horrible sin, something that earned him the shunning of civil society. If you're squeamish, you should probably pause the video and brace yourself to hear about Bostock's despicable, naughty crime. Are you ready? I sure hope so. In 2013, Bostock... Oh, I'm sorry. I'm getting shivers. In 2013, Bostock began participating in a gay recreational football league. Horrible, I know. How Clayton County didn't do something about this wretched agent of chaos earlier is beyond me. He had us all fooled. The praise Bostock used to get for his good work got swiftly replaced with criticisms for his sexual orientation, and Clayton County terminated his contract for, quote, conduct unbecoming of its employees. Bostock v. Clayton County is consolidated with Altitude Express v. Zarda, a case dealing with a similar issue though with a different background. Zarda used to work as a skydiving instructor for Altitude Express, and he made it a rule for himself to disclose the naughty, mischievous fact that he's a gay man to his female clients to prevent any sexual discomfort. On one occasion, however, this backfired tremendously. After he skydived with a client, Skydove? After he did the skydiving thingy with a client, said client accused Zarda of touching her inappropriately and using his gayness as an excuse. As a result, he was fired, and now he contests his firing as based solely on the fact that he's gay and non-cis normative. Now, the consolidated Bostock case argues that these 2 instances represent a violation of Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination because of sex. More specifically, the Equal Employment Opportunity Commission is defending the position that discrimination on the basis of sexual orientation is a form of sex-based discrimination. So now it's up to the court to either legitimize the position or dismiss it. If the plaintiffs lose in this case, that means that there are no federal laws currently protecting employees who are anything but heterosexual. The other case I mentioned, RG and GR Harris Funeral Homes, involves Amy Stephens, a trans woman who got terminated from her position as funeral director after she let her employer know that she was planning to transition. During the 6 years Amy had worked there, she presented herself as male, the gender assigned to her at birth, and the company had no problem with that. But, of course, the announcement that Amy was in fact not a male was simply too much for the broken-hearted company to process. As is popularly known, cis people make for wonderful funeral directors. Obviously. But having trans people in the company comes with the risk that their twisting of essentialistic gender views will ultimately extrapolate into a twisting of the time-space fabric of reality, which will then inevitably collapse onto itself and result in an ever-expanding black hole of gender queerness whose one and unique goal is the death of meaning in the West. And that would be just too much for the cleaning crew to handle. Janitorial well-being is evidently the top priority of the company higher-ups.
Remember, businesses care about you. The market will set you free.
Like the Bostock Consolidated cases, RG and GR Funeral Homes will base its decision on Title VII, arguing whether transgender people are a federally protected class. Next, we have Kaler v. Kansas, a case you may have missed, but that I find quite relevant in matters of mental health in the criminal justice system, namely whether states have the ability to abolish the insanity defense in court. Before we proceed, I want to give a serious content warning for mental illness and family violence. So if you want to avoid this section, skip to the timestamp on the screen. I'll wait for a moment in case you need some extra time to pause the video. We good? Let's go right in then. This case concerns a man who became abusive toward his wife and estranged from his children following a series of intramarital problems. Kaler would come to show signs of mixed obsessive-compulsive, narcissistic, and histrionic personality. Even though he was prescribed medication, he refused to take it. After some time, Kaler shot and killed his wife, his daughters, and his wife's grandmother. In court, his attorneys pled that Kaler was not in his right mind and required mental health care treatment, not imprisonment. The issue here is that the state of Kansas abolished the insanity defense by law, meaning that violent lawbreakers, regardless of their mental state, ought to receive equally harsh sentences. Now, I want to take this opportunity to dispel some myths about mental illness that I have seen tainting people's perspectives on the matter. The first is the idea that the insanity defense is used as a get-out-of-jail-free card by people abusing their privileges. The problem with this is that not only is the insanity defense used in less than 1% of all criminal cases, but that when it is invoked, attorneys have to prove beyond any reasonable doubt that the defendant is truly not in the right mind. And as anyone with a basic understanding of human psychology may tell you, mental illness is not something one can just fake when necessary. I also want to tackle the idea that the prison system is the most appropriate place for mentally ill individuals because, well, that's just not the case. If we value rehabilitation and restoration over simple eye for an eye retribution, we gotta be aware of how ill-equipped the United States justice system is to deal with neurodivergent inmates, whose conditions typically get worse by the harsh environment of the prison industrial complex. This is honestly a much more complicated conversation that merits its own video. But until then, I sincerely ask you to not dismiss the problematic nature of mental health in the legal world. If the Supreme Court rules against the insanity defense, it may be doing just that. And the line between mental health and criminality in our nation will be blurred more than it already is, affecting people whose situations may not be as gut-wrenching as Kaler's killings, but still heavily punishable under the law. The following case, U.S. Department of Homeland Security v. Regents of the University of California, is on DACA, the Deferred Action for Childhood Arrivals policy implemented in 2012 that kept many immigrant children from being deported to their nigh certain deaths and offer them some basic human rights. Not too many for them to think they're as good as US citizens, but enough to keep the public from being too harsh on Obama for his otherwise hideous foreign policy. As the kids say these days, thanks, Mr. Deporter-in-Chief. In case you don't know much about DACA, it was an executive action shielding undocumented children from deportation and allowing them to work and pay taxes. DACA implemented what Congress had been failing to enact for over a decade at that point with the DREAM Act. The detail is that executive actions are not very long-lasting, as new presidents can just mandate the opposite of what the previous president did. And, lo and behold, that's exactly what Trump did. Sort of. Defenders of DACA now argue that the Trump administration, more specifically the Department of Homeland Security, dismantled DACA incorrectly and, therefore, said dismantling is illegitimate. In response, the DHS argues that the implementation of DACA did not conform to proper procedures, so DACA itself is illegitimate. And so the question for the Supreme Court to address is twofold. On the one hand, can the court protect an improperly implemented policy from the agency that implemented it to begin with? And, on the other hand, is the improper dismantling of that policy unlawful? Adding fuel to the fire is the fact that the issue in question, immigration, is a huge one for President Trump's cultists. I mean, worshippers, supporters. I may need glasses. You all probably remember how Trump started his presidential bid in 2015 with horrendously xenophobic rhetoric, and he's followed through as president. White nationalism is possibly the greatest source of support for the Trumpalumpa, and the fact that this case is happening right as he prepares for his re-election campaign is nothing short of foreboding. Look at it this way: if the court rules in favor of Cheeto Man, he'll celebrate it as a victory, and his base will feel increased social cohesion in their divine quest to own the libs. If the court affirms DACA, however, Meerkat Toupee and his base will spin it as an establishment move against their supposedly populist movement and lash out in ways that are difficult to predict, but that based on these past couple of years are likely to be hellishly vicious. Either way, we're probably going to see some social upheaval following this decision, and the least we can do is be prepared to counter the proto-fascist reactionaries. Following that, we'll get Comcast Corporation v. National Association of African American Owned Media. This case revolves around Entertainment Studios Network, the only multi-channel media company in the US fully owned by African Americans. Whoa, they have a media company now, and they still complain? Unbelievable.
We've, tried to deal with our original sin of slavery by fighting a civil war, by passing landmark civil rights legislation. We've elected an African-American president.
Darn leftists and their historicism and their systemic understanding of oppression. The crux of the problem is that Comcast refused to carry any of ESN's channels, a thing that also happened with other huge carriers. ESN sued Comcast by alleging that the latter was violating African Americans' equal rights to contract, and this is where the case gets a tad messy. Because we now live in a post-racial society, and by that I do not mean that there is no racism, but rather that people in power do not want to acknowledge that racism is still a driving force in market relations, it falls on ESN to demonstrate that Comcast was being deliberately racist against them. At least that was the verdict of the district court, but on appellation the circuit court ruled that racism doesn't have to be the driving factor, just a provable factor. So now the Supreme Court must decide which is it. Can ESN claim that there was racism in the decision, or are they screwed unless they can somehow prove that there was nothing but pure racism on Comcast's part? We'll have to see, though I personally am not very optimistic about this one. That's a grim enough place to stop, I think. I'm sorry, but you already saw the title of the video. You knew this was coming. There are too many impactful cases to discuss in just one video, so this one is gonna be a two-parter. Don't worry, part 2 is going to be the next video I release. Doesn't that alone make me better than most big YouTubers? That was a mean joke. I'm sorry. It's not about competition. I'll be good now. I hope you found this video to be informative, and I appreciate your patience as I work on part 2 of this. Is this a mini-series? I don't know what the minimum number of episodes something has to have to be considered a mini-series. Leave a comment if you know. Make me smarter.
Feed the mind brain.
So, I guess this is as good a time as any to mention that I have a Patreon and a Ko-fi account. So, if you like what I do and want to lend me a hand, check them out. It would help me a lot if you have some spare change. Plus, there are a couple of nice perks. Nothing super pricey, but you can check them out on the website. They're both in the description box. Remember to like and subscribe if you like my stuff and if you want to continue getting notified about when I release my stuff. And also comment and share so that the YouTube algorithmic masterlord will push these videos more and help the channel grow. It's a crappy system, I know, but it's the only one we have, so the least we can do is exploit it to our benefit. Again, thanks a lot for your continued support. That's all I have for today, but I'll be back in a couple of weeks with part 2. I will be seeing you there. Until then, take care.